Right, so hi, how are you doing? My name is John Diking and welcome to the channel. Today we're going to discuss tax and legal updates for expatriates in Spain. I'm a proud wealth manager at Buchanan. I help expatriates all over Spain with the financial planning. So we look at our clients' savings, investments, and pensions. And my job is to make sure that everything is set up in a way that fits your goals and is as tax efficient as possible here in Spain. I'm joined by Sally Myburgh. She's an administrator in a Facebook group called After Exit in Spain, and she's helped 38,000 members over the years. We also have a new guest today, Debbie Ryder. She's an administrator at Paralegal for Malaga Legal, and she helps her clients with legal support and administrative tasks. So all three of us have in common that we've lived in Spain, in Andalusia, in the south of Spain, for over 20 years. And we have a lot of life and work experience over these years that we want to share with you. So hopefully this is going to be helpful for yourselves. We're going to focus, as I said earlier, on the most common tax and legal issues faced by expatriates here. If you have any questions which you wish to discuss with us on an individual basis, then please get in touch. You will find the contact details at the end of this video. And I would also like to offer everyone who's watching a complimentary financial review myself. And there'll be a link to book the review at the end of this video as well. Right, so let's look at the topics we're going to discuss. So we're going to cover Spanish visa, Spanish residencia, NIE applications and TIE renewals, capital gains tax and the sale of UK property when moving to Spain, UK inheritance tax changes between 2025 and 2027, and planning points linked to UK inheritance tax. So I'm going to pass you on to Sally, who's going to tell you about Spanish visa.
Okay, thanks a lot, John. Right, well, welcome to my garden in the Serrania de Ronda. There have been a few changes this year. For a start, the Golden Visa, which I think had a lot of publicity in the UK, has gone. The Golden Visa, which is the nickname for the investment visa, was intended to bring money into Spain, and you could buy into government bonds and government utilities. And then there was a sort of soft option, which was €500,000 unborrowed to buy property. And unfortunately, by the end, about 90% of the applicants were exactly that. And when it came in 2014, €500,000 might have been quite a lot of money. You can get you a golden visa, but by 2025, it really wasn't relevant anymore. So it went on the 2nd of April. Now, I do have to say that existing visas, people who've already got the visa, you will be able to renew in exactly the same way as was current when you applied for the visa. So it's not retrospective, it's just that there are no more applications. There's also two indicators that are used quite often for calculating visa income. One is the SMI, which is the Salario Mínimo Interprofesional, which is basically Spain's minimum wage. And that now stands at 1,184 a month. But it's a slightly odd one because historically in Spain, people were paid in 14 months over the 12 months. You were paid every month, and then you got an extra payment in the summer, and you got an extra payment in December for Christmas. And so the actual annual amount of the minimum wage is 16,576. And there are various visas, particularly the UGE, the business visas, that are usually based on that. The other indicator is the IPREM, which is the Indicador Público de Renta Efectos de Múltiples, which is basically Spain's cost of living index equivalent. Now, that hasn't gone up for 3 years. This is the third year that it's 600 a month or 7,200 a year. And the most popular visa probably that we come across is the NLV, the non-lucrative visa. Some people call it the retirement visa, and that is based on the IPRM. That is 400% for the first person, which actually works out at 28,800, and for every other person in the family, it's another 100%, so another 7,200. That hasn't gone up, as I say, since 2023. So I think that is quite likely to go up next year. The SMI did go up a little this year. Right. The other thing is there was a lot of talk about the non-lucrative visa and how it was going to change, and how after the first year you were going to get 4 years renewal, and that didn't happen. And people were quite worried because with the 2-year renewal, if you any part of it that's savings, or if you're only using savings, had to be double because it was a renewal for 2 years. And people were worried, of course, that it would be 4 times the amount, but it hasn't happened. That's never changed. Okay. There are a couple of changes to it. One is that they're now asking for a certificate of average balance from the bank, and you can get that in Spain from a Spanish bank, but actually British banks don't do them. So if it's a new application or your bank account is only in the UK, then what you need to do is a print off 12 months, do a manual summary, and attach it. And then they do seem to be accepting that. The other thing is that up to now, you had to have a paid for and active health policy, technically, when you went to the application. And you couldn't get it back if you if you didn't get the visa. But now they're saying that they will allow them, if they're prepaid, they can be post-dated to a more realistic date of when you're actually going to leave the UK. Okay, so John, can we have the next slide, please? We're now going to talk about the new BOE. Now, BOE is the legal bulletin of Spain. When new laws come in and they've been passed, they produce a bulletin. In this particular case, it was 232 pages of very closely typed A4. So it took quite a lot of unraveling, and we're still unraveling it. But there have been some significant changes now on that. One of the main changes that affects everything is that they are now saying, and I quote, "The Immigration Office will automatically obtain the report from the Central Register of Convicted Persons to verify the absence of criminal records in Spain, and will obtain a police report on the applicant. These reports will be issued in 7 days." So it shouldn't cause much of a delay, but it does mean that if you've been hiding something, they are likely to see it. But it also goes on to say the existence of antecedents of crimes in the police report will not in itself automatically constitute grounds for denying the visa. Now, that is a change, because the old one didn't say that, although actually in reality, that is exactly what they've been doing in the last few months. It will be assessed on a case-by-case basis. If the crime doesn't even exist in Spain, then it's not relevant. If it does, but it's not against public order, internal security, public health, or public relationships with other EU states, then the chances are they will let it through. But it's a bit of a lottery. Now, let's go on to the student visa. The student visa has been amended yet again. It was amended a couple of years ago. And basically, if you are on a degree course, you are getting an even better deal. If you are on one of the sort of lesser courses, language courses or whatever, then it's changed slightly. The higher education courses and the specialist health courses will permit you to bring your family. Obviously, you have to financially be able to justify that, and they mustn't have a criminal record, but you can bring family. But no longer can you bring family if you are applying for a visa for a language course or a lesser course, or a course that doesn't end up in the equivalent of a degree. It doesn't actually have to be a university degree. It can be the equivalent from a business institute, but it does have to be degree equivalent. For degrees, they will issue the visa for the length of time of the course. So if the course is 3 years, you will get a 3-year visa. But the institute at the beginning of each year does have to confirm that you have paid and that you have succeeded in the previous year. So you can't just get it and go off and do something else. You will get time with a degree to go off and look for a job, and then to convert it into a working visa, which is very good. For pretty well everything else, you renew after a year. For secondary education, non-degree courses, you will be allowed to apply for 2 extensions. But for general voluntary, general training, languages, preparatory courses, the preparatory health courses, and the language assistance and vocational training, it's 1 extension and that's it. Okay, the financial means for student visas remain exactly the same. They haven't changed at all. It is the IPRM for the student, which is 600 a month, and for the first family member to join them, it's 450, which is 3/4 of the IPRM, and for every other family member, it's 300. So that hasn't changed, and that's quite a low level actually, and it can be adjusted if the degree course you're doing or any of the courses you're doing include accommodation. They take that into account. Right. Now, the working visa, sorry, excuse me, the working visa has got a change in that after the first year, you will then get 4 years, not 2 and 2. And that is because the government want people to come and work in Spain and stay and feel secure. Because at the moment, you know, it can feel a little bit, where am I going to get my renewal? Have I, you know, left everything behind? So that's a really good change. Now we also have a range of Arraigos. Now these are new Arraigos. They have been completely reorganized, and there are really sort of 1 new and 1 old amended, or 2 old amended actually, and then a couple of revised. They are, I'm just briefly going to go through what they are. There's the Arraigo de Segunda Oportunidad. This is a second opportunity. This is for people who have had a permit, a residence permit, in the last 2 years, but for some reason, their fault, somebody else's fault, whatever, hasn't renewed it. And therefore, they're now here irregularly. All of these Arraigos, with the exception of Arraigo Familiar, which is completely changed, are for 1 year, and you are required to have been in Spain for 2 years, not 3. That is a change. The Arraigo Social before, you had to be irregular or illegal in Spain for 3 years. Now it's only 2. Right. So Arraigo de Segunda Oportunidad is for those that have had a permit to live in Spain in the last 2 years, but for some reason don't have it anymore, but have stayed. There's the Arraigo Socio Laboral. This is for people who've got 1 or more employment contracts, that in total of all of them, they are at least the SMI, the minimum wage, which was 16,576, I think, thereabouts, and that the work is at least 20 hours a week. If it is only 20 hours a week, not full-time, then it's pro rata to the SMI. Okay, 2 years again. And again, you only get the Arraigo for 1 year. Then there's the Arraigo Social. Now, that's been around for a while, but that now is if you have ties with a foreign person who has a resident permit, that could be a spouse, a registered partner, first-degree relative, which is parent or offspring, then you can apply for the Arraigo Social. If you don't have that connection, but you've been in Spain for 2 years and you can support yourself, or you're being supported by somebody, then you have to do the social integration route. And that is a report prepared by the town hall and the social services. They present it to the autonomous region, basically saying that you have integrated into Spanish life. And that can include, it doesn't have to be all of them, but it can include training activities, knowledge and respect for the Constitution of Spain, statutory values of the autonomous region, value of human rights, freedoms, democracy, tolerance, equality, and where appropriate, it includes basic knowledge of the language. That is quite important. Right. There must also be sufficient funds. So if you're not working, you have to have at least 100% of the IPREM, and it has to come from relatives or some private source if you're not working, or from self-employment. You can actually apply for self-employment, and they will take that into account. There's also the Arraigo Socioformativo. Now, this is really a revision of the Arraigo de la Formación, what was always known as the training Arraigo. It's now known as the social training Arraigo. This is for people who there are two options. You either agree to train with the Public Employment Services of Spain and you into something that is in the national employment situation. Now, when they use the term national employment situation, they're basically saying it's a catalogue of occupations that not a lot of people do. So they have always a limit to how many candidates they can get for the jobs. So you are training to do something that Spain really wants to be filled. Or you can actually do one of the training courses that's actually part of the student visa as well, which is compulsory secondary education, or language assistant, or you can do language studies in Spain, or one of the co-official languages of Spain, which are quite varied, like Galician and Valencian and Catalan. You can do preparatory courses for specialized health training, so you then can go on to do the proper health training, which is like degree level. You can do training in technical certification or professional qualification, and you can do vocational training at grade C to levels 2 and 3. So it's quite broad. There's quite a lot of different trainings that you can do, and you will be allowed to work up to 30 hours a week, so long as you're paid up to at least the level of the SMI for the job. Okay. In all cases, I said before, the Arraigo is given for 1 year. And then after that, providing you've done what you've said and you are working, or you've succeeded in your training, or you go on doing the training, you will get 4 years work visa. So it's a good deal for anyone who is illegal or irregular in Spain. Now, the other one, it's a change of slide again, please. The other Arraigo is the Arraigo Familiar, and I'm going to do this in the reverse order of this slide. This is known as family roots, but it has completely changed. It was the Arraigo if you were married or if you had a Spanish civil partnership with a Spanish national, you could apply for the Arraigo Familiar. It has nothing to do with that now at all, because there is a new Spanish family card, and I'll go on to talk about that in a second. It is now a sponsor, parent, or a guardian of a minor, the minor who is a citizen of another EU country, or the EEA, which is the economic area, which includes Norway, or Switzerland. So it's now moved out really to being non-Spanish people, but who are in the EU or the associated countries. Or it's a person who provides support to a disabled person who is an EU citizen or part of the EEA or Switzerland, and is a family member in charge of living with the disabled person. Okay, for the Arraigo Familiar, there is no time that you have to have been in Spain illegal. It's as it was before. It's something you move straight into, and the visa is immediately granted for 5 years. After that, of course, you become a permanent resident. So now let me go on to talk about the Spanish family card. This is completely groundbreaking. They've never had anything like this before, and it is a much more simplified version of people who are Spanish who want to bring their families to Spain. Before, you either use the Arraigo Familiar, but that required a registered relationship, marriage, or pareja de hecho, which is the Spanish civil partnership, or if you were allowed to, but most regions wouldn't, you could use the family EU card. But this is now specifically for family of Spanish nationals. This is nothing to do with other EU countries. You can bring 3 sets of people. Partners, they can be your spouse, your married spouse, but they have to be over 18. They can be your civil partner, and it will be a civil partner who is recognized by Spain. Their civil partnership is recognized by Spain. Some areas may accept a UK civil partnership. A lot of areas don't. Or it can be an analogous partner. Actually, if you've got a civil partner and that civil partnership isn't recognized, you'd be analogous anyway. That is a relationship where you have lived as man and wife for at least a year, and you basically have a strong and stable relationship, or you don't have to prove any length of time if you have children. If you both have children and you're both on the birth certificate, that counts. Okay, you can also bring your children. You can bring the children of the Spanish national or of their spouse and partner or partner, as long as the spouse and partner is still living with the Spanish national in Spain. They can be up to 25, well, under 26, so up to 25 or over 25 if they're in your care. Now, when they talk about that, they're talking about either disabled children or children who cannot cope on their own, but it has to be documented that you are their carer. It can also include adopted children, so long as they're under 18 and so long as you have the sole custody of them or the written permission, legal written permission of the parent or the other partner. So it has to be proper notarized consent. Now, you can also bring parents in direct line of either the Spanish national or the partner, spouse. It can be the parent, guardian, or tutor of a Spanish minor, but they would be expected to be living with them, or there may be a different arrangement, but their obligations have to be up to date. That's what it actually says, up to date obligations. It can also be a single family member up to second degree. Now, that is a grandparent or a grandchild. Okay. And it can be sons of daughters of a parent who is Spanish by option. Okay. Now, those members, there are it has then a really weird clause which says it can be other members of the family that aren't included in any of that, but they presumably are going to be considered on a case-in-case basis. And it also includes minors where abandonment can be proved. That's part of the humanitarian aspect of it, I suspect. They will be allowed to work. Once they're here and they're on the visa, they will be able to use family reunification, which means they'll be able to bring other members of the family. And this permit lasts for 5 years. And again, if you're here the whole 5 years, then you become a permanent resident in your own right. There are 3 ways of applying. If the Spanish national is in Spain, but the family member is in their own country, then the Spanish national will apply for this in Spain. It's a bit like the family reunification. They apply, they get the permit, and then the family member uses the permit to apply for the visa in the UK at their consulate. Or if both parties are outside, like you're living with your Spanish husband in the UK, then in fact the family member will apply to the consulate. Okay, but you have to be intending to live in Spain. This is not so that you can be you wouldn't want this visa if you weren't going to come and live in Spain. Or if both parties are already in Spain, which is sort of a less usual scenario, then they will apply together at the provincial Extranjería, which is the provincial foreigners department, either themselves or they can use a representative. So that's quite exciting. That's something very, very new for this BOE. Really, it's nice to see everything to do with immigration in one document. It's making life a little bit easier for us. Just before I pass on to John, can I just say that our site is completely free. You don't have to join, but if you want to participate, you need to be a member. It is public, so you can just look through all of our information posts, which are on Facebook. It's called After Brexit in Spain. We are only volunteers. We have no paid service behind it at all. Everything we provide you with is completely free. We are aware that however much we go through the theory of the national bulletin or anything else, at the end of the day, there are regional variations. So we also have sort of on tap some really excellent specialists who we absolutely trust, who will provide answers to us for nothing. And Debbie, who I'm going to hand you over to in a second, is actually one of those specialist people that we love. So so do come and join us, please. You're very welcome. And all this information that I've given now is available on our site. And now I'm going to stop talking and pass you over to Debbie.
Wow, thank you very, very much, Sally. That was really, really interesting. Thank you. Yes, as Sally said, we've got these new rules coming in on the 20th of May. What we don't have are the instructions yet. So when the instructions come, we're going to see a little bit more how it's all going to be applied. And it'll be a bit of a suck it and see, and we'll find out a little bit more about exactly how the rules are going to be, and they will be applied differently, I'm quite sure, in different regions. But we've got to wait a little bit for those, and then we do have people who are waiting for that date to see certain small aspects of what they're hoping to do, to see exactly how we're going to do it. Now, I'm going to talk about some traditional stuff like residency in Spain. So a lot of us got residency before Brexit. We're British, we got it this way. And we have people contacting all the time about getting residency. I've just had just before we started this, I've just had an inquiry from a gentleman who's married to a lady who has an Irish passport. Lots of people are managing to get EU passports, and so hopefully they get residency, which is relatively simple. And then the family member, the partner or the children who don't have an EU passport, because Sally's term, she always says piggyback. I always say, don't say that, because it's harder than piggybacking, because they are constantly changing what they're asking for. It's not quite that simple. And people can make some really rookie mistakes when they're applying for residency as the partner of someone who is an EU citizen or indeed a Spaniard. So let's start off with talking about those of us who've got the WA protected Brexit TIEs, either the 5-year, or some of us got a permanent one because we'd already done the 5 years as a resident before that. So people who can sort of try to piggyback on with those are people who had the relationship existing with the person who is a resident before Brexit. So I'm British, I'm a resident, I was married before the end of 2020. If my husband had been living in a different country and now wanted to come and live with me in Spain, and there are plenty of people who did this, only one of them got residency for their own reasons, now he could apply as my spouse. And the family, the Foreigners Office affectionately call this one family of Brexit. So Brexit has a family. Equally, we've got children who were born before Brexit, and they can also get residency if their parents have residency. We are getting quite a lot of inquiries, which are a little bit upsetting in many cases, where weirdly the parents or one parent has residency and the children don't, and they don't then get the child residency, which would be relatively simple if they can show that they can economically look after their child. They're waiting until after the child is over 18, and it's creating quite a lot of issues. It's a bit of a moot point whether the child has to be under 18 for them to apply as the child of their parent, or whether we can go to an older age. And the Foreigners Office in Malaga have said, yes, they can be older. But if you have a child and you have residency and your child doesn't have residency, the time to act is now and not once they become an adult and are trying to find a job or something like that, because it can be really tricky for them. So also looking at these ways of applying for residency as a family member of a Spaniard. And I think really Sally's talked about this a little bit, and also as the family member of an EU passport holder. Going right back to what I said at the start, for example, wife has an Irish passport, husband has a UK passport. It's the same as wife has a German passport, husband has a Argentinian passport, for example. It's the same thing. One's EU, one's non-EU. Important points to remember are for the EU person to get residency as soon as they can in the various ways. I've got a blog on our website about this. And then for both of them to do everything possible to get documentary evidence of really being physically in Spain. Okay. And it's something people overlook, and they make really, to me, they're silly mistakes, which they're not realizing that they're silly until it's pointed out to them. They're keeping the UK phone number. They're only using UK banks, for example. They're not getting involved in anything when they're here. They say, oh, I'm doing Spanish lessons, but they're doing them online. What you really need to do is to act like you live in Spain even before you apply for residency. Okay. Use Spanish banks, get a Spanish phone number. They want to see that kind of evidence. I've taken people to the foreigners office because we've been asked to physically go. It's called a comparecencia. And the person in the foreigners office has said to me, if he wasn't here standing in front of me, I wouldn't believe he was here. So we need to join clubs, go and do some charity work, this kind of thing. Get your kids into school, walk people's dogs, get a letter from somebody, take your pet to the vet and get the vet to write a letter. Get involved in things. Clubs, organisations, places where you can make friends. You've just moved to a new country are all the things that probably people should be doing anyway, but can be also documented. Okay, so I'll move on to the next slide now. I think I've covered that. Okay, so now we're going to talk about different pieces of paper and card. Okay, the first I have a prop. It's the NIE certificates. Okay, unfortunately in Spain, and loads of people are guilty of this, banks, even sometimes policemen or women, and all sorts of people will say you need NIE. Okay, this, well, I've Tipexed it. This is somebody's NIE certificate. Okay, it's an A4 sheet of paper. Nowadays they're digitally signed, so there's no real original. Got a QR code and things like that on them. And so that says that person has an NIE number. That could be somebody who wants to buy a house in Spain. Perhaps it's an unfortunate person who's someone's passed away and they're in the will and they need an NIE number to inherit, to buy a vehicle, to buy property, and so on and so on. That is just an NIE number, and it confers no rights at all to anything, and says at the bottom, this certificate does not accredit your situation of either stay or residency. It just has an NIE number. Okay, then these are for EU citizens. This is somebody's, and I've Tipexed their name. I'm afraid it's been used as a drinks mat, not by me. And it has their NIE number on it. It's actually called a Certificate of Residency of EU, known as a CUE. Okay, that's a residence card that a lot of us Brits used to have, and anyone coming from an EU country, EU passport, that's the residency type that you get. The disadvantage of it is it has no photo on it, and it's also really flimsy. But no, you can't swap it for a plastic card, unfortunately. It just is what it is. So the first one has a 5-year duration, and you are supposed to renew it for a permanent one, a 10-year one, although it doesn't actually have an end date on it. I don't know who designed these. Okay, how to apply for these? At the National Police Station. Most police stations will ask you to be on the Padron, on the town register, although notable exceptions don't, which is very handy for us. If you are not working with sufficient money in the bank, and it's not a very high bar, it's really the EPREM that Sally was talking about, approximately that amount, 7,000 and something is sufficient, and also either a private Spanish private health insurance policy for a year, or an S1, if you can get an S1, if you're a pensioner from any EU country or the UK, which we did not lose this right in Brexit, or if you're already working. So here comes Irish Debbie, gets herself an NIE number and has the right to work in Spain. I start working, I either get a job or I become self-employed. At that point, I don't need to prove any funds. I don't need to buy a private health insurance because I'm clearly earning something and I'm paying into the social security system, or my employer is. And so I can just go and get one of those once I've started work. So it's relatively simple. You go in, as long as everything's in order, you get the card at the same time and they print it out for you while you were there, unlike the TIE. Now, the problem is sometimes people arrive. Gentleman today has been to the bank. They said, you can open an account as long as you've got an NIE, which is what they always say. And when he goes tomorrow with it, I wonder if they'll say, oh, but it's not green, because that happens all the time. And it's, you know, maybe people should need to take with them a picture of them and say, which type do you mean? So that they're not getting the wrong one. There's always a solution, go to another bank, etc., etc. But the problem is that you will hear people saying NIE or NIE, meaning that, which is when they should be meaning that. So that's relatively simple. So that's the first partner. Now, NIE applications, the same place as these, are at the National Police Station. Talking about the TIE card, which I don't have a prop because although I have one, it's not with me at this moment. The TIE card is the nice plastic practical card which has your NIE number on it and also has your photo. And we were able to apply for TIE cards from the second half of 2020. And there are a huge number of people who have a 5-year TIE card that's going to expire in the next few months. So a lot of people are concerned now about the renewal. Now, up until about 6 months ago, we were all pretty sure that the renewal was going to be handled by the Foreigners Office, which would mean going to the Provincial Foreigners Office in person or making an application yourself or with a professional through the electronic system, which is called Mercurio. By a mad coincidence, I was actually in the police station the day that they received the call telling them that the Foreigners Office are not going to deal with this. I think there would be too much of a deluge. And it was decided that TIE card holders of the 5-year TIE would do the renewals at the National Police Station. You can renew from 1 day after your 5-year TIE expires. And the ruling was, and let's see how it's interpreted, certainly in our area of Malaga, they are only going to be asking for the X23, the tasa of €12 paid, photocopy of passport, a new photo, and an up-to-date padron, which means that's very, very simple, because back to Irish Debbie, if Irish Debbie was going to renew that for a permanent one, I would have to prove my full 5 years in Spain with tax returns, bank statements showing that I've had health insurance and things like that. So it's a little bit unfair, but it's been taken as a measure to simply stop the police or the Foreigners Office being completely avalanched with work. So the TIE card, 1 day after expiry, you can apply for a new one. If you already have a permanent 10-year one, you can apply at the National Police Station again 1 month before your card expires. So you may end up, if your new card is ready in a month, you may end up that you never have a card that's expired. Whereas the 5-year people will have to have an expired card for some time until they can get the new TIE card, perhaps 3 or 4 weeks or something like that. Now, some people like me and Sally, we had these and then they were exchanged for TIEs. In some police stations, people are being allowed to get a permanent TIE if they can prove the 5 years in Spain. Some of them with a green one and some of them with a TIE. Where we go, in our part of Malaga, the system only trips to say that you can have a permanent one if you've moved house. So if the address on your TIE card is not the same address where you're on the padron, astonishingly, if you had one of those before and you've got a TIE card and it's 5 years since you got one of those and you've moved house, so the address on your TIE card is incorrect and you're on the padron at your new address, if you go in, you will come out with an application for a permanent TIE card. Well, nobody really knows why. But for most people, it will simply be just wait until your card expires. But thank goodness we do not have to go through the hell of all applying to the Foreigners Office more or less at the same time and providing masses of proof of 5 years of physical, legal, tax, etc., residency in Spain. Okay, unfortunately, the family members of the Brexit TIE holders, unfortunately, until we receive any other news, we are told it is going to remain as now, that the renewal application has to be made through the Foreigners Office, proving that you are still with the person with whose residency you were able to kind of piggyback on, or that you were for at least 3 years. And I'm afraid they're probably going to have quite a wait until their residency is approved due to the sheer workload that the Foreigners Office is going to have. So that could be made in person at the Foreigners Office or it could be made electronically. It's worth mentioning that during times when people have an expired TIE card, they have a new card being made and they're waiting to go and collect it, or that they have a renewal application in process, they can always get what's called an autorización de regreso from the National Police, which is a travel document. It's like a pinkish coloured paper, which they can show at the border leaving and entering Spain. So if you're going to America or somewhere, and then you've had to come back into Spain and you've got no TIE card that shows that's current, that shows that you're still a resident, it's worth getting yourself a regresso, and it's relatively simple to do. Okay, is there any more slide for me, John?
No, it's fine, Debbie. Thank you so much. It's been really helpful.
I've not forgotten anything, have I, Sally?
No. Just before we move on to my slides, can you please tell us a bit more about how you can help expatriates in Spain, Debbie?
Yes, well, we get a lot of enquiries about all sorts of different things, a lot about residency and getting NIEs. We get a lot of NIEs for people. I can give them some advice. We can make applications for people. If they're nearby, we can always accompany them. We can do things by power of attorney as well, which we can arrange. Generally speaking, what I'm doing at the moment, apart from my normal things, I'm keeping a diary of when people's cards expire so that I can get them an appointment for hopefully one day or a couple of days after their current TIE expires, and then we can get them the next one ordered. I work with 2 fantastic immigration lawyers called Marta Moreno and Emma Romero, who have been in this industry for many, many years, doing projects for autonomo visa, all sorts of Arraigos and different types of residency and immigration issues. They have absolutely years of experience, and basically they've taught me everything I know. So if anyone wants to get in touch, then we will do our very best to assist. Thank you.
Thanks so much, Debbie. And I have a personal experience of using your services, so I can highly recommend you. And I'm also part of the Expat in Spain, so I do encourage people to join. I've been a member for many years. I know, Debbie, you're a member as well. It's a really helpful site. There's lots of valuable information, which is being checked very thoroughly to make sure it's all accurate and up to date.
Great.
So we're going to move on to talk about some financial and tax issues. I'm going to talk to you about something that, as a financial advisor in Spain, one of the most common queries I get is about capital gains tax when you sell a UK property. So there hasn't been much change recently to legislation around that, but just because it's such a common query, I thought it's worth just spending a few minutes discussing it to make sure that people understand it. It's a little bit complex, but I'll try to just make it simple. So the key considerations you should have is that when you sell your main residence, it differs from selling a buy-to-let property. So when you sell a buy-to-let, an investment property, that's always going to be taxable both in Spain and UK. However, if you sell your main home, that may be exempt. So it's very important to point out that timing is important. So the tax liability depends on your age, for how long did you live in a property, and when did you move out? What's your country of tax residence at the time that you complete the sale? And are you reinvesting the proceeds into a Spanish property? And we'll need to take into account also that there is a double taxation agreement between Spain and the UK, which is designed to ensure that you don't pay tax twice on the same item. So normally, if there is a UK tax at source, which there would be to sell a UK property, then you would get credit for that tax on your Spanish tax return. So let's look at things from a UK perspective, first of all. So you live in Spain and you sell a UK property as a Spanish resident. So UK capital gains tax rules say the following, that there is no capital gains tax if you sold the property within 9 months of moving out, if you've always lived in a property. Whilst if this was a property that you rented out for part of the ownership period, then there would be a proportional capital gains tax relief in the UK, whilst the last 9 months of the ownership will always be treated as main residence. For people that live in Spain and sell, then the capital gains tax liability is only calculated on the gain that you've had from April the 6th, 2015 until the sale date. So if you bought a property before that date, there'll be no capital gains tax on that portion of time. And even if you live in Spain, because it's a UK property, you will still get a £3,000 per person UK capital gains tax allowance, which you can apply against the UK taxable gain, if there is any, on the sale. Now let's move on and look at the Spanish side of things and look how Spain looks at capital gains tax. So again, you live in Spain, you sell a UK property. If you've spent at least 183 days in Spain in the year that you've sold it, it means that you are a Spanish tax resident and a capital gains tax liability would apply in Spain. However, there are exemptions to this. So if you're over age 65 and you've lived in a home for at least 3 years, then you have 2 years to sell it completely tax-free from a Spanish perspective. If you're under age 65, there's still an option to sell it tax-free if you reinvest all the proceeds into a new primary residence in Spain within 2 years. But again, you must have lived in a property for at least 3 years to qualify for it to be your main residence to get this relief. A third option, which applies generally to investments and capital gains, not just property, is that you can reinvest into whole of life annuity, or what's called renta vitalicia in Spanish. This is an option for people when it comes to property. You got to be over age 65, and you can only get up to 240,000 exemptions. So if you sell, for example, a property for 500,000, you can reinvest 240,000 into this option, and 260,000 would not be able to be reinvested with that exemption. If there is any taxable element, if you can't apply the exemptions, then the profit will be taxed at 19 to 30% on a sliding scale. And you can knock off any deductible expenses, which tend to be capital improvements like swimming pools, garages, etc., but not wear and tear. So if we just wrap things up and just to give you like a holistic perspective, best tax strategies to sell a UK property, and the easiest thing to do is that you sell it before you become a Spanish tax resident. So you sell the property whilst you still are a UK tax resident, and you must ensure that in the year that you complete the sale, you don't spend more than 183 days in Spain. So you can spend less than 183 days, because otherwise you become a Spanish tax resident and the sale could be taxable in Spain. You should also ensure that your accountant applies any exemptions correctly, so you can knock off from the if there is a taxable gain, you can knock off expenses which are related to sale, like agent fees, notary fees, etc. You should make sure that they are applied fully for you, and normally you need to have invoices made in your name to do that. So you should try to keep any documents like invoices for the future if you have a property, because they can be potentially knocked off from the game. And then it's always, it's always good to get professional advice, because many people that have had a property, especially main residence, they may have had it for many years. They may be a very large gain, which potentially could be sold completely tax-free. You do it in the right way and the right, time. Time is very important. So this is something that I advise my clients on, and this is something that I think you should definitely discuss with someone that understands the rules before you actually, sell the property. So we're going to move on to talk about inheritance tax. So I think many of you may be aware that in October last year, the UK Labour government introduced some very large changes to taxes, and especially inheritance tax. And this has impacted on expatriates who live in Spain, and also people that are looking to move down to Spain in the coming years. So we're going to start with just looking at the previous rules and how they've changed and what's going to change in the next few years. So previously, there was something called UK domicility or domicile for estate planning for inheritance tax. So normally, someone that was born in the UK, and especially if their father was born in the UK, there will be a UK domicile person at birth, and it means that you have, very strong ties to the UK. And previously, if someone moved to Spain and they live in Spain for many years, they could still be deemed as a UK domicile person, which meant at the time that there could be UK inheritance tax on their entire estate, including worldwide assets and not just assets in the UK. So this is like a really important consideration for people that have moved abroad. And we had a lot of uncertainty at the time, because if you went to HMRC and you said that, look, I've severed lots of ties with the UK, I don't have any UK assets left, and I've lived in Spain for lots of years, and I feel like I've become a Spanish domicile of choice, then they would never give you a straight answer in your life if they believe you to be UK domicile still or not, or if they agree that you are a Spanish domicile. So this was something that was always tested in the event of death. And at the time that there was a probate process. So at that time, they tried to determine, was this person a UK domicile person or not? So one of the, I guess, positive changes we've seen recently for expatriates in Spain is that as of the 6th of April this year, the term domicile has been abolished. There's no more domicile test, and domicile of choice terminology, like domicile of choice in Spain, that's been abolished as well. And the rules have become much more clear, which helps us to plan ahead so we can set up a partnership fund for our clients. So if someone leaves the UK and they've been resident outside the UK for at least 10 years, it means that there are no longer long-term residents in the UK. So there are no non-long-term residents at that point. And that means that they are what was previously called non-UK domiciles. So at that point of the 10 years, if they die in Spain, then only assets in the UK will be assessed for UK inheritance tax, and not assets outside the UK. So any properties you have in Spain, cash in Spanish banks, or if you have investments abroad, as long as they're not in the UK, then they wouldn't be assessed for UK inheritance tax. So that's really important for people that live here. We're gonna move on and I'll look at other changes. So yeah, we said about the non long-term resident. I think there's some things that still remain. So previously there was a 325,000 mill rate band, which was applied to UK assets, whether you were tied to the UK or not. That was always exempt from your estate, so that still applies. So even if you live in Spain and you've been here for over 10 years, you have some UK assets left, maybe UK property, you have a 325,000 exemption against your UK assets, and anything above that amount could be taxed at 40%. However, the spousal exemption still remains. So if you're married and you pass your assets on the first step to your spouse, then you can pass assets to each other, and normally that's fully exempt. So let's look at pensions. So there's been some changes to pensions as well, and those changes have been announced, but they will begin on the 6th of April 2027. So previously, actually no, currently until 2027, all UK pensions are free of UK inheritance tax. So pensions are currently not an estate asset. However, after April 27, there'll be an assessment for UK inheritance tax, and it could potentially be a 40% tax on unused funds in UK pensions. So we think this is something pretty new, and we'll need to see exactly how this is described in the law, etc. And there may be some changes for 27. But as it stands right now, we understand that the final salary schemes are probably unaffected by this. So this is going to be linked more to money purchase schemes, private pensions, etc. And state pensions are excluded as well. So it's got to be pensions that can be inherited, and pensions where you can put a value to the pension a bit easier. So let's look at a few examples. I think when it comes to these things, it's always good to just illustrate the point with some numbers. So imagine that you have a UK property worth £500,000, a Spanish property worth £500,000 as well, and a UK pension. So under the old rules, if this was a married couple with those assets, on first step, there'd be no UK inheritance tax because the UK pension was not part of the estate. And the UK property and Spanish property, which add up to 1 million, could be exempt with the nil rate bands, because each spouse had a nil rate band of £325,000, so that's 650 between them. But they can also benefit from a residential nil rate band against the main home, which could be applied even if you live in Spain. So it doesn't have to be main home in the UK. And that could be up to £175,000 per person. So you can have a 1 million exempt for a couple, and there could be no tax for a couple that had 1.5 million assets previously. However, if we look at the new rules, then currently, because UK pensions will be part of the estate, it creates a bit of complexity and hassle and administration. So there's now going to be a need for probate, which can take like 3 to 6 months, maybe more. And the inheritance tax needs to be calculated by the pension scheme administrator, the personal representative, or HMRC. If you die before age 75, then your beneficiaries will not pay UK income tax on the pension income that they draw from your inherited pensions. However, if you're over age 75, then the beneficiaries will be liable to UK income tax. And this is not new. This was the case before as well. So if you have beneficiaries outside the UK, how they are affected depends on the country where they live. And pensions are currently a bit of a complex area in Spain, so it requires specialist advice. It's good to have a proud conversation about UK pensions when you live in Spain. So let's look at an example. Like if you have a UK pension fund with £500,000 left, and at the time you die, there is always, after April 27, there's going to be always a 40% tax if this pension is in excess to your nil rate bands. So the tax will be £200,000. So you got 300,000 left. Now, if you died when you were over age 75, then your beneficiary will be taxed at the marginal income tax rate. So if it happens to be an additional tax rate payer, then there'll be 45% tax, so that they will pay 135,000 in tax. So if you add up the income tax and the inheritance tax, the total tax bill is £335,000 on a £500,000 pension. So there's only going to be £165,000 left in the pot after you paid all the tax, and the total tax is 6 to 7%. So as you can see, it's really harsh, and this is one of the reasons why you need to completely change your strategy for estate planning when these new rules come in force, and it's important to plan ahead for that right now, because whilst pensions used to be an estate planning asset, people try to leave pensions for beneficiaries. Currently, such UK pensions are no longer an attractive asset to leave, especially if you happen to die over age 75 because of all tax. So we're going to look at some planning points, just knowing these new rules that have come in force or about to come in force, and how it impacts on our clients here in Spain. So I think in all cases, you should aim to stay in Spain for at least 10 years. That's really, really helpful, because that makes you a non-long-term UK resident. And it means that, as I said earlier, that only your UK sited assets will be liable for UK inheritance tax. And this has to be 10 consecutive years as well. So you got to be careful with the time you spend in the UK. So if you were to spend less than 10 years in Spain, then your worldwide assets will be taxable on second death. So if it's a married couple, for example, on first death, they can have a spousal allowance in the UK, but on second death, the global assets could be taxed, not just UK assets. And this will include pensions after April 27. But if you've spent more than 10 years in Spain, as we are recommending, if you can, then only UK assets are taxable. But those UK assets will include UK pensions after April 27. So there's nothing we can do about that. I think Labour, they when they introduced this new rule, they thought perhaps people would transfer the pensions out of the UK to avoid the inheritance tax. And for this reason, it may be for this reason, they introduced an overseas transfer charge on pensions. Previously, if you transferred to Malta or Gibraltar and moved to Spain, this transfer charge was not applied. There was an exemption in place, and now this will be applied. So if you move to Spain and transfer your pension to Malta, they will take a quarter of the pension value in tax. So it doesn't really make sense. So I think for most people, it just means that they need to leave their pensions in the UK, which means that there would be inheritance tax after April 27. And this just means you need to really plan ahead and look at your estate planning, inheritance tax planning, just knowing that your estate is likely to be inflated over time with this new pension being included. So it's important to consider moving assets out of the UK, because now that pensions are added to your asset base in the UK, and there's nothing you can do to get around it, even if you spend 10 years in Spain, you can consider moving your assets out of the UK and reduce the assets in the UK that could potentially be above your nil rate bands to save 40% tax on the excess. So that it can be quite easy to move liquid assets out, like cash, investments, etc. You just move in to another country, that's all. And you need to make sure that there's no detrimental tax impact in that country. So this is why we can help out and plan ahead with those things for you. You need to review your UK and Spanish wills. So because of the whole planning bit needing to be reviewed, you may need to, as a result, update your wills, because there may be some changes you want to make to beneficiaries, etc., to be more tax efficient. And you can also consider gifts. So you can still do what's called PETs, or potentially exempt transfers, which means that if you are still what was called previously a UK domicile, or if you are a UK long-term resident because you haven't spent 10 years in Spain, then you can still, from a UK perspective, take assets out of your UK estate by gifting them, for example, to a child. And if you survive for 7 years after you made a gift, that gift will be totally exempt from UK inheritance tax. And if you die in the meantime, during these 7 years, there'd be a proportional relief. So some of the asset will still be part of your estate, but not the entire value. You can also gift non-UK assets, and that can be really efficient, especially if you spent over 10 years in Spain. It's worth mentioning trusts is something that are not. This is like a structure, it's very UK focused, or Channel Islands, etc. People use it in UK for tax planning, whilst in Spain it doesn't work very well because Spain doesn't recognize trust. They haven't signed up for the Hague Convention, so Spanish legal system doesn't recognize trust, and it just creates lots of issues. So I do recommend that if someone has a trust and is looking to move to Spain, that you seek professional advice to see what needs to be done about a trust before you become a Spanish tax resident. And there are structures in place in Spain that can be used for Spanish tax efficiency. An example of that is the Spanish compliant investment bond, which can act similar to an ISA in UK, where you can have tax-free capital growth. So if you want any more information about that, then please contact myself. Right, so we're just coming to a close, and we hope that this has been interesting for you and useful. I want to encourage you to approach us if you have any questions. You can see our contact details on this slide here, and if you pick up your phone and bring up the camera, and if you scan the QR code on the screen, then you can book a complimentary video call with myself. So I'll be happy to give you a complimentary financial review to discuss your particular questions, your circumstances, perhaps you're moving to Spain and I want to make sure you're tax efficient when you land here, or you may already be in Spain and you just want to review what you currently have and see if you can make anything more efficient. So I'm happy to discuss it with yourself. So I'd like to thank Sally and Debbie for that participation today. It's been really, really valuable and useful as always. And thanks to everyone for watching. And if you like this video, then please consider giving it a thumbs up. It really helps me. Please do it. It's going to reach more audience, and please share this with your friends as well. Anyone you know that lives in Spain or is looking down that would benefit from this this recording, then please share it with them. Sally and Debbie, do you have anything else that you want to add before we finish?
No. But...
Right. Well, thanks again to Sally and Debbie. Thanks to everyone for watching, and goodbye. And we hope to see you on the next video. Thanks.